I wanted to explain that the Los Angeles Superior Court, a Superior Court judge on April 22nd of 2024, struck down Senate Bill 9, which was actually enacted in 2021 as Chapter 162 by the legislature and governor. And SB 9 dealt with approvals for housing development in the state. According to the Assembly floor analysis, SB 9 requires ministerial approval of housing developments with 2 units, duplexes, and subdivision maps that meet certain conditions. It also increases the length of time that cities and counties can extend the validity of existing subdivision maps. Moreover, the bill included findings and declarations of the legislature that changes that were proposed by Senate Bill 9 address what's called a matter of statewide concern rather than what we call a municipal affair. And as a result, SB 9 declared that it applies to all cities, including charter cities. So, Section 4 of the bill provides the following. The legislature finds and declares that ensuring access to affordable housing is a matter of statewide concern and not a municipal affair, as that item is used in Section 3 of Article 11 of the California Constitution. Therefore, Sections 1 and 2 of this Act, adding Section 65852.21 and 66411.7 to the Government Code, and Section 3 of this Act, adding Section 66452.6 of the Government Code, apply to all cities, including charter cities. And that's all it says. Now, 5 Southern California cities successfully sued Attorney General Bonta to prevent the enforcement of SB 9. According to the judge's written decision, petitioners contend that SB 9 violates the California Constitution because it's neither reasonably related to its stated concern, which is ensuring access to affordable housing, nor is it narrowly tailored to avoid interference with local government. The trial court judge ruled that because the provisions of SB 9 are not reasonably related and sufficiently narrowly tailored to the explicit stated purpose of that legislation, namely to ensure access to affordable housing, SB 9 cannot stand. The court explained that the principal question presented in this case is whether SB 9 violates the authority granted to charter cities under the California Constitution, which is to govern and manage their municipal affairs. All 5 of the cities that sued are charter cities, as opposed to what we call general law cities. Now, Article 11, Section 5A of the California Constitution allows charter cities to legislate regarding municipal affairs. General law cities, on the other hand, are subject to control by statutes enacted by the legislature. And with regard to municipal affairs of these charter cities, the legislature is prohibited from interfering in the government and management of that municipality. However, in certain limited circumstances, the California legislature can override the charter city's power to govern its municipal affairs when the legislature enacts a statute that is reasonably tailored to the resolution of a subject of statewide concern. The court said that in helping the judicial branch determine whether a state statute can affect a municipal affair, our Supreme Court has developed a 4-part test to meet. And the trial court, in its 12-page written decision, went on to analyze SB 9 under the 4-part test. As the court explained, a critical question presented in the instant writ petition is whether the explicitly stated intent found in the text of SB 9, again, which is providing affordable housing, should be deemed the relevant statewide concern, or whether the court may look elsewhere to identify a different statewide concern, which is increasing housing supply, that's purportedly meant to be addressed by SB 9, notwithstanding what the legislature said. So the court opined, put another way, can the statewide concern unambiguously expressed in Section 4 of SB 9, remember that's the section that had the legislative findings and declarations, can it be reformulated when that concern fails the 4th step of the inquiry? And in response to the court posing this question to itself, the court finds that the answer is no. Now, as a matter of legislative drafting, the court explained that the legislature's intent in Section 4 is unambiguous. The legislature plainly declared that the statewide concern addressed by SB 9 is, quote unquote, ensuring access to affordable housing. So the court presumes that the legislature meant to address affordable housing because that's what the legislature said, not some other statewide concern. Moreover, the court opined that a court cannot reformulate the legislature's explicit declaration of statewide concern in contravention of its plain language in Section 4 of SB 9. Finally, the court ruled that SB 9 is neither reasonably related to ensuring access to affordable housing nor narrowly tailored to avoid unnecessary interference in local governance. SB 9 is therefore unconstitutional as violative of the Home Rule doctrine. Now, why is this court decision also a lesson in legislative drafting? Because, in my opinion, it reiterates that a statute, as well as the bill's plus sections, such as the statewide concern finding that is specified in Section 9 of SB 9, will be given their usual and ordinary meaning by a court. As a result, when the legislature makes a finding and declaration to justify the application of a statute, it must be clear, consistent, and comprehensive in that declaration. In the future, for example, more detailed findings would likely be of benefit to ensure that the legislature provides an appropriate basis for a court to find as it intends. Instead of short, conclusory statements, a more expansive explanation would be a better approach to take. And the bill analyses of these measures should ensure that the bill language and the committee analysis complement each other, and perhaps even some Section 1, like uncodified findings and declarations, might be appropriate as well.